because I'd like us to be his friend, but not if it sets
No,
you
of
off like
course.
this.
Look, I'm live. Reading Chapter 5, Defenses from UCC Sales.
Doesn't matter. You guys played great.
Skipping a chapter problem. Figure 5.2 shows the effect of contract defenses. Contract formation being the first, followed by a chart where one direction is there are no contract defenses and the contract is ultimately enforceable. The other way is contract defenses exist under sections 1-103, 2-201, 2-302, and the contract is unenforceable if those contract defenses are asserted. In this chapter, we study Article 2's, just write it down, Article 2's defense provisions.
Would have bothered us more if we were as good as you and meant as much.
Figure 5.2 illustrates
Like, we didn't come with the expectation to win.
Effect of contract defenses. This is the introduction to the chapter. In this chapter, we study Article 2's defense provisions. As Figure 5.2 illustrates, the effect of contract defenses is to render a contract unenforceable. Article 2 is not codified all of the defenses that historically were raised to prevent unenforcement of certain contracts. However, under Section 1-103, the common law defenses are applicable to sales contracts. The common law defenses include fraud, mistake, undue influence, duress, lack of capacity, and unconscionability. Also, courts historically have refused to enforce some contracts on public policy grounds. Sometimes courts refer to those contract defenses as illegality. Unconscionability and the statute of frauds are the only defenses to formation that are explicitly codified in Article 2. Then you see Figure 5.2 I just walked through. Defenses again. At common law are fraud, mistake, undue influence, duress, lack of capacity, unconscionability. The contract defenses under the code are codified at 1-103, 2-201, and 2-302. I yet do not know what they stand for. Oh, fraud, mistake, undue influence, duress, capacity, unconscionability, and public policy are defined at 1-103, also known as the common law defenses. 2-201 involves merchants and a writing, which sounds like statute of frauds, and 2-301 is about unconscionability again, but under the code. 1, the statute of frauds. You will recall that under common law, several types of contracts usually were subject to the applicable statute of frauds. These types of contracts included contracts for the sale of goods above a certain price. Although the elimination of the statute of frauds was considered and hotly debated during the recent UCC Article 2 revision process, the UCC continues to retain a statute of frauds. To deconstruct Section 2-201, first determine whether the statute applies at will. A contract to which the statute of frauds applies is commonly said to be within the statute of frauds. See Figure 5-4 is a contract within the statute of frauds. Is a contract within the statute of frauds sale of goods for the price of $500 or more? Yes or no? If yes, the contract must satisfy the statute of frauds. See Figure 5-5. If no, the conclusion is that the statute of frauds will not bar enforcement of the contract. Next, if you determine that a contract is within the statute of frauds, you must see whether the statutory requirements are met. If not, the contract will be enforceable. Will not be enforceable, Figure 5-5 illustrates the questions that must be resolved to decide if the requirements of Section 2-201 are met and the statute of frauds is satisfied. First in the waterfall, is there some writing? If no, the conclusion is there is a possible statute of frauds defense. Continue to exceptions. Is the writing, this is next in the waterfall, is the writing sufficient to indicate that a contract for sale has been made between the parties? If yes, go on. If no, the conclusion is there is a possible statute of frauds defense again. Continue to exceptions, which are in the next figure. So if the answer were yes, and you continue through the waterfall, the next question is is the writing satisfied by the party against whom enforcement is sought or by an authorized agent/broker? If no, it's the same conclusion. If yes, the conclusion is that the statute of frauds will not bar enforcement of the contract. It looks like the requirements were met. And the requirements, I have read I have in the margin here on page 77, 2-2012, merchants, if within a reasonable time, a writing and confirmation of the contract and sufficient against the sender is received, and the party receiving it has reason to know its contents, it satisfies the requirements of subsection 1, unless receiving party objects in 10 days. 2-2013, note, a contract which does not satisfy the requirements of Section 1 but is valid in other respects is enforceable. A, if goods are specially manufactured. B, defendant concedes there is contract. Or C, payment accepted/made and accepted. Figure 5-5, which I just went through, indicates that if a contract fails to satisfy the requirements of Section 2-201, number 1, it is premature to reach a conclusion regarding unenforceability. Instead, as shown in Figure 5-6 on the next page, you must first analyze each of the exceptions in Sections 2-2012 and 2-2013, see if they apply. Note that in Sections 2-2012 and 2-2013 must be deconstructed for proper analysis. Section 2-2012 is particularly complex. Exercise 5-1, deconstructing sections 2-2012 and 2-2013. 2 is confirm between merchants, and 3 is exceptions. And I actually just kind of read the statute on those sections. There is an exercise for deconstructing those, skipping through, but there is Figure 5-6 on the next page, exceptions for contracts that fail to comply with 2-201 subpart 1. The statute of fraud exceptions is the top of this diagram. Even though Section 2-2011 is not satisfied, contract may be enforceable under one of the following exceptions. Talks about written confirmation between merchants from Section 2-201 subpart 2, specially manufactured goods from Section 2-2013A, party admits contract in pleadings, Section 2-2013B, and partial performance, Section 2013C. Mark this page because it's important to see those statute of fraud exceptions. Conclusionary remark: if an exception applies, the statute of frauds will not bar enforcement of the contract. Now, I'm going to skip exercise 5-2, which involves a read of the Remap International Corporation versus Comfort Keyboard Company case, starting on page 79. Going through to page 86 and picking up with part 2, chapter 5, defenses of about unconscionability, I believe. And that's going to be essentially it for the chapter. So the doctrine of unconscionability focuses on the formation stage of the contract. Unlike an assent analysis, however, an unconscionability analysis does not examine whether the parties agreed to the disputed terms. An unconscionability analysis focuses on 1, the bargaining process leading to purported agreement to the terms, sometimes referred to as procedural unconscionability, and 2, the substantive fairness of the disputed terms, substantive unconscionability. If a court deems a term unconscionable, it will strike the term from the contract. When the contract as a whole is unconscionable, the court may refuse to enforce the entire contract. The unconscionability defense developed in the equity courts, where chancellors used the analysis to police bargains which appeared to be unfair, but which resisted attack under traditional contract defenses. Although the defense long predates legislative enactment, its use became increasingly widespread after its incorporation into UCC Article 2 and the Restatement 2nd of Contracts. Most jurisdictions have applied the doctrine not only to transactions governed by Article 2, but also to contracts outside its scope. The most common approach to an unconscionability analysis follows the framework first outlined by Arthur Leff in his seminal article that critiques Section 2-302 for its failure to include a definition of the term. However, although Section 2-302 is itself silent on how to determine unconscionability, the official comments give some guidance. Specifically, it can be inferred from the official comments that the basic test of unconscionability is whether, in the light of the general commercial background and the commercial needs of the particular trade or case, the clauses involved are so one-sided as to be unconscionable under the circumstances existing at the time of the making of the contract. The principle is one of the prevention of oppression and unfair surprise. Citation omitted, and not of disturbance of allocation of risks because of superior bargaining power. The official comments reflect Leff's proposed analytic framework. He advanced a 2-pronged analysis where a court will not enforce the term if it finds both procedural and substantive unconscionability. Procedural unconscionability typically rests on defects in the bargaining process, such as clauses that are buried in fine print or lack of negotiations over terms. On the other hand, terms are substantively unconscionable when they are unduly harsh or one-sided. Although most courts follow Leff's view that elements of both procedural and substantive unconscionability must be present before a term is unenforceable, many have adopted the viewpoint that a sliding scale is appropriate. That is, the more egregious the procedural unconscionability, the less substantive unconscionability need be present, and vice versa. In a minority of jurisdictions, terms may be excised upon proof of either procedural or substantive unconscionability. Both are not required. Immediately after states began adopting Article 2, parties rarely raised unconscionability defenses, and those who did had little success. Gradually, however, the number of reported cases involving an unconscionability defense swelled. These cases usually involved the unenforceability of particular standard form contract terms. If a court deems a clause unconscionable, the court will not enforce it. Sometimes the behavior complained of is so severe that a court will refuse to enforce the entire contract. What most of the successful cases tend to have in common is a consumer defendant who signed a standard form contract. Cases involving sophisticated business people who have successfully asserted an unconscionability argument are almost non-existent. However, courts have been willing to rule in favor of non-consumers who raise the defense that they lack business sophistication and legal representation because they more closely resemble a consumer than a business person. Decisions based on unconscionability are fact-sensitive and to a great extent reflect trial judges' subjective determinations. As a result, although there are now many cases that address unconscionability, they have little value as precedents. One can make predictions as to the outcome of the particular case based on how closely the facts resemble a reported decision, but ultimately it will always be necessary to await the decision of the court. And then additional resources follow to finish the chapter 5 on contract formation defenses. And there.